നിങ്ങളോട് ആ സോപ്പിടണം മോളെ സോപ്പിടണം. അരി 5 കിലോ.
Thank you so much, guys, for joining. We will start the session at 7:10.
Hello, everyone. Hello, I'm audible to everyone? Okay, we are going to start our meeting within 2 minutes. Thank you for your patience. Hello, everyone. Very good evening to everyone. Please, I request you to everyone, please open your camera or turn out your camera. Hello, I'm audible to everyone. I request you all, please turn on your cameras. It will be more interactive if you will be in the camera. We can see you, we can interact with you. Please, it's a request. Everybody, please turn on your cameras. So let's start our session. First of all, I would like to welcome you all in the era of this IPR. Very, very much thank you for everyone giving your precious time to us. Here today we are going to start with the IPR session, and we are going to tell you about the what is IPR is, what is the filing process, and each and every part of IPR law, so that you are able to understand how this APR is coming in our life as a blessing. It will help you to secure your intellect. It will help you to make you understand how this way we are able to make our future bright, because all of you are from that particular criteria or the category that I hope that all of you from colleges or from our research and development departments. So it's a very big achievement in itself, and that is why we are here to have a blast in this webinar, so that it will be more helpful and productive in so many manners. So on this commencement of this webinar, I would like to call Mr. Venkatesh Bharti and Ms. Swati Varshane, who is already with us. Mr. Venkatesh Bharti is also a director and the founder of Vastav Intellect IP Solutions LLP. Is a passionate towards the innovative approaches. He's an awardee from DRDO and awarded by Mr. Rajnath Singh. He's having more than 100 patents already in his name. So I would like to call him, and I request him to please share his knowledge and experience with us, so that it will be, this webinar become very productive. And at the same point of time, I also want to welcome Ms. Swati Varshane. She is the advocate and the IPR patent agent, as well as the trademark attorney. Very ambitious patent professional with 15 years of experience, and also having the prosecution for different jurisdiction in India as well as abroad. So again, a big hand of applaud for her, and I also welcome her to come and share her experience with us. So over to Mr. Venkatesh Bharti and Ms. Swati Varshane. Thank you so much. Okay. Yes, please.
Thank you so much, Deepa Kohli, and thank you so much, Ms. Swati Varshane, to joining this session. And I would like to thank everyone to join this session, which is conducted by NIPAM and Vastav Intellect IP Solutions. So thank you so much to Swati Varshane ji for joining this session, as well as giving their prestige and knowledge to us. And so today we are going to start and work on and discuss the topics on IPR, what is intellectual property rights, intellectual property rights kya hote hain, how we proceed on this, how we can secure our rights, and a lot of things that we know that we are using in our daily basis, but we don't know how we are utilizing it and how we are securing our daily IPRs. So I think this is the right time to start the session. So I would like to invite Ms. Swati Varshane, and I am going to share this session. And this session is going to be very interactive. If you have any doubt regarding the IPR, you can just write it in the chat box. You have the opportunity to write in the chat box of whatever question that you have. And so let's begin the session.
Yeah.
I hope my screen is visible to everyone.
Yes, sir.
Okay. So it is going to be a faculty development program or intellectual property rights and a awareness program on IPR. Okay. So these are the topics that we are going to discuss in this session: importance of IPR, tangible, intangible, why IPR rights are important. I would like to request everyone to please turn off your mics till the session, and you can write your question in the chat box, so we can smoothly run the session and end the session with a good pace. And discussion on types of IPR, relation between intellectual property, industrial designs, copyright, geographical indication, and trade secrets. These all are the terms are very like what we can say habitual and in daily life use in our day in a daily routine, but we don't know how to utilize that particular thing. So today I am going to tell, and so Ms. Swati is going to tell you how and where you are utilizing these rights and how you can secure your IP. So first thing first, what is tangible and intangible? I would like to ask you guys question. What do you mean by tangible and intangible properties? Because there are the major difference between in that what is IPR. In IPR, tangible and intangible are the both most common and most differentiable thing. Does anybody know what is tangible and intangible? You can write your answer in chat box. What all are the tangible property? If you want to turn on your mic, you can. Anybody? Okay. So tangible are the properties, are those properties which can movable or maybe immovable, like our houses, our car, our money, our jewelry, whatever the things that we have, like sofa, TV, television, machine. These properties are known as tangible properties. What all are the intangible properties? The properties which cannot be moved, like patent, design, trademark, copyright, and
Yeah,
GI.
like
These also are the properties.
yeah, Venkatesh. So like the things which we cannot touch, like which is in our mind, which is in the visualization. So how can we say that this is ours? Because
Right.
this does not have any boundary. Like for a tangible property like a plot, it is having a boundary. Like a flat, it is having a boundary. But if you are having a creative thing in your mind, which you cannot touch, so how you can say that that is yours? So IPR is for that thing.
Right. So I'm going to discuss in like very short discussion what is the difference between tangible and intangible property in IPR. Like जो चीजें आपकी मूव कर सकती हैं, जो चीजें नहीं मूव कर सकती, which is in particular boundaries. अगर if we talk about like if we have a plot and we are just fencing it around, these have the boundaries. We cannot, there certain boundaries are restricted that particular property. But in intangible properties, these restrictions are not applicable. Like in patent, design, trademark, copyright, and GI. Okay. Now, what are the importance of patent and what are the importance of IPR? These are the genuine rights. These are the rights which can be awarded and rewarded by the person who have the individual rights. And these are the monopoly rights, legal rights. For example, I have an idea to make a mobile phone. Okay. So I have an idea to make a mobile phone, how we can secure that mobile phone. So if somebody else will not like use this technology in their like invention or innovation. So there is, to secure that particular rights, we have intellectual property rights. Okay. These are the topics on which we are going to discuss in intellectual property rights, and these all are the departments of the IPR. Okay. Everyone knows like what is trademark. Everyone knows like what is copyright. Everyone knows like what is patent. But nobody knows what all are the IPR. People are like, we have, if they have a trademark, अगर उनके पास trademark है, they are like, we have a copyright. We have a copyright on certain thing. They are telling like, we have a patent, and I want to do a trademark on that particular patent. So you know everything, but the terminology, the main discussion, the main particular point is very much known to you guys, but you are unable to describe it. So today we are going to tell you what all are the departments of IPR. IPR is like, if we talk about a registration process on a social media platform, there is some registration process to register yourself. If you are a business owner, you have to register in the business owner form. If you are a user, but individual user, you are going to register yourself in an individual user. Or if you are a separate entity, or if you are a like creator, so you are going to register in a creator platform. Same like in IPR. IPR is the main source. There are particular departments on this. Like in IPR, there is a patent department. In IPR, there is a trademark department. In IPR, there is a copyright, industrial design, plant variety, trade secret, layout, and geographical indication departments. In each department, we secure our rights. If we talk about only the patent is here to secure the technical rights. Trademark is here to secure the 2D design of right, 2D design of a particular design. Copyright are only for the artistic work. Industrial design are only for the 3D designs. We will talk about more in depth about these topics, but right now I'm just explaining you which right is going to which particular department. Okay, so these all are the particular departments of IPR. Anything like you want to tell, Swati ma'am?
Yeah, so like every right is having its importance. Like you cannot say that I am going to patent my design. So design will be registered under industrial design and patent will be filed for its technical part. So IPR as a whole has a very
wide is exposure of things like trade. A product which is in the market is having a patent, it is having a trademark also, and it is registered under a design also. So it is having some boundaries for different criterias. You cannot say that your product is having patent for its trademark. It is a very different thing. Patent is a different thing and trademark is a very different thing. Now we are going to explain this to you through our slides. Like you will get to know about how patent is
Okay.
different from design. So like for example, this is a mobile phone. So everybody is having a mobile phone in their hands, and they say it is having a patented thing. But what is patented there? So the technical part is only patented, and the design is registered under the shape. A shape is registered under industrial design, and trademark is for the logo only. You cannot say that that the technical part is having a trademark. Trademark is only for its brand name. And in the same manner, the color tone or any kind of jingle you listen from Samsung, that is copyrighted. So in this way, this is simple device is having 4 IPRs: design, patent, trademark, copyright.
Okay. So, I'm going to carry forward this. So, okay, for example, there is a mobile phone, right? And if I talk about, okay, let's assume a car. There is a car known as BMW, right? The technicality of that BMW is like how the engine is working from point A to B, B to C, and C to D. How the engine is connected to every part. For example, the propellers are connected to the engine, and the pipes are connected to that particular part, and pipes are connected to like radiator. All this, how these all part is connected to each other. Every technical aspect is going to be registered. These all are the registration processes. These all are the registration departments. Is going to be registered in patent department. Every technical part are going to be registered in the patent department. Many people come to us and they are like, we have any management related, we have a management related thing. We have like we have some algorithms. We have something which is non-technical. Can we do a patent of this? No, we cannot, because patent is only and only about the technical part. Some people come to me, some professor comes to us like, we want to do a utility patent. Utility patent is not come into the Indian department. There is only a word exists in India is patent. So no utility patent in India. Another thing was like, what is design? Design is a patent or it's a trademark? Design, industrial design is something else and trademark is something else. Okay. So for example, if we talk about, there's a water bottle. This bottle is an industrial bottle. We can utilize it. I can like put water or something orange juice in this. So this is an industrial design. Any design which can be manufactured and useful to the user is going to come under the industrial design. If you talk what is trademark, if you know that, please write in the chat box. Okay, these all are the trademarks that we see usually in any supermarket or in any like mall or some market as well. Yahoo, Adidas, all are the trademark section. So how these trademark is different from industrial design, because these all are the designs, these are the artistic work, or can we if these are the artistic work, why cannot we secure these designs in copyright section? Right? All these questions has come under our mind at that time when we study about IPR. So there is something else, some differentiation. If we talk about designs, these all are the 3D designs. You can touch it, feel it. If you can touch it or feel it in the x-axis, y-axis, and z-axis, then it is going to become under the design section. Every part of a shoe, every part of this Lamborghini, every part of this chair, jewelry, water bottle, heel, even your sari patterns, even this cup, even this watch, every part of this particular watch comes under the industrial design if it is useful for the user. Okay, so I would like to invite Swati to explain what is trademark. You are on mute, ma'am.
Can you go to the previous slide?
Okay.
The description of trademark. Yeah.
Okay. Yeah.
So trademark is generally for a brand or a logo. It is for any name or a mixture, like or a combination of name or numerals or some alphanumeric numbers. Anything can be made, or any combination can be made for filing a trademark. And it can have a image also. Like if you see Nike is having some logo with it, so that logo and your brand name or together comes under the trademark. So any device or a symbol, any like the name by which you market your thing comes under the trademark.
Okay,
So
Swati
it
ma'am,
can have any color.
I'm going to ask you one question so people
Yeah.
can relate more. Can I
Yes.
do Starbucks? Can I take a trademark on Sardar Bucks rather than if already Starbucks is present in India or in
No,
anywhere
no,
in the
no.
world?
No, it
How?
can
Why?
it can be said that it is nothing is creative there. It is a just a copy of Starbucks. So like there is a decision also on Starbucks only that this is just a copy or this is misleading trademark. Like people at a glance will look at the Starbucks and they will think that okay, maybe this is a Starbucks only. So this kind of trademarks comes under misleading trademarks and they are not allowed.
Okay. So anyone have any question? Tell these slides so we can proceed for further things. Okay,
Yes.
everyone knows now what is design. Design is the outer portion of any particular invention. Like for example, how this mobile phone is look alike. वो mobile phone दिखेगा कैसे? How this mobile phone is looking is going to be registered in the industrial design section.
Yeah.
How this mobile phone is working is going to be registered in the patent section. Oh, yes, technical part. What is the symbol of this design or this particular invention? Like which mobile phone, which industry or which company is going to be manufacturing this? The logo part is going to be registered in the trademark section. Whenever I am going to start this mobile phone, whatever the jingle and gimbal is going to be produced from this particular device is going to be registered in the copyright section. So these all are the different departments where we registered each and everything of a particular invention. Now, we talk about so till we talk about patent, trademark, copyright, and industrial. Now we will talk about plant variety, and I would like to invite Swati ma'am.
Geographic indication even discuss. Yeah. So plant variety is for the plants. As you see by the name also, this is for the new varieties of plants which are prepared by hybridization and by different methods. So these rights do not come under patent. They cannot come under design. So there is a specific right which is called plant variety right for these kind of things. So like we have to provide the information for that harvested material, like
Right.
what is new in that, what is the distinct thing in that plant variety. Like you have seen that we come across many varieties of rice. So most of the varieties are registered under the Plant Variety Act.
Right. Okay.
And how and we have to provide the information about the uniformity of the right of the variety or how stable they are. Like it should not be like that this year this variety is available, next year maybe this variety cannot be available, or the seed which you are using is not stable. So plant variety cannot be provided for those kind of seeds or plants, but it should be stable for different generations.
Right.
So for
Even,
these things, the plant variety right can be provided.
even we cannot make one variety by combining two other varieties. Like if we are combining A plus B and we are producing C, so we cannot do that in any
Yeah, something
department of
new should be
industry.
there.
Yeah, in any department of IPR, if you are making the
Yeah.
combination of any by taking the combination of two things and making some new things, you cannot do that because this is going to be
Yes.
the it is not going to be the part of IPR. You have to work on the novelty part, then what on which particular thing you are claiming. For example, right now we are claiming that me and Swati Varshane is taking a session with all of you guys. We claim that because we know it's a fact. And if, what is the myth here? If I talk about me and Deepa is taking the session with you guys, this is a myth that is not applicable to claim. If something we cannot claim, the claim is not appropriate or not novel, so it is not going to be registered in any IPR section.
Yeah, so IPR is about the intellectual thing,
Right.
intellectual property right. So anything which you are creating on your own, then that you can register in any one of the IPR right, like patent, trademark. It should fall under any of the right.
Right. If we talk about like I am going to invent an air conditioner, and this air conditioner is not going to be work with the gases or any compressor, or this air conditioner is going to be worked by the hot water. Okay. So we can only claim that the air conditioner is already existing, but we are claiming that the air that air conditioner is producing is coming from the hot water. I am going to claim that. Only we can take the part if we can only register that particular part on which we are claiming. If we claim our the whole air conditioner is our, no, the invention that we are making, like the hot water is producing cool water, oh sorry, cool air, then only we can take the claim, and then only we can get the grant of that particular patent. How this air conditioner is looking alike, which is going to be registered in the industrial design, and how what sound that particular air conditioner is producing when we are turning it on. So that particular thing is going to be registered in the copyright, and what logo that air conditioner is consisting of, which company like Whirlpool or any XYZ, it is going to be come under the trademark section. Okay, just wait a minute. Now we are going to study upon what is PCT application, which is also a very, very big concept. And this is going to be taken by Ms. Swati Varshane. Just give us a second and we are switching the slides. Hello. Yes. Do you have any doubts, sir? You can ask any doubt if you have any doubt regarding if you are a professor, if you are an inventor, if you are a advocate, anyone of you have any doubt on any particular thing like patent, trademark, you can ask simply. Okay. Even you can write it in the chat box. My slides are visible to everyone.
Yes, sir.
Okay, thank you. Even in the end of the session, we are going to do a chit chat round where you can ask any questions. Okay, types of patent application in India is going to be taken by Swati ji. Over to you.
So now we have discussed till now about what is IPR, what is the difference between patent, trademark, design, copyright. Now we will discuss particularly about patent. What is patent? What are the kind of patent application we can file? What are the different ways to file a patent application in India and abroad? So what is a patent application? So when we file a patent in India or any other country, that is called patent application. So that is the application for the grant of the patent. Till now, the patent is not granted. The application will be processed by the government. You will get objections, or there will be some formalities. Then you will get the grant. It is not like that you have filed the patent application, you are the owner of that patent. It is not like that. That is the patent application. Then after the processing, you will get the grant for the patent. So there are very many different kind of patent applications, like patent of addition, divisional application, provisional, complete. We will discuss them each and every application separately. So Venkatesh, can we go to the other slide? And you can full screen the slides.
Yeah. Okay. This one?
Yeah. So first kind of application is a provisional application. So this is a legal document which is filed for early filing date. Like you have some idea in your mind, but you want to protect it, and at the same time you want to work on this idea for some additional data or some additional results. So that at that time you can file a provisional application for that concept, and you can take time for 1 year and file the complete application within the 12 months of time, so that your application can get examined. So you get the time for 1 year, like that you can work on that idea or your research work, and at the same time you have protected your filing date or the priority date, that after that date if anybody is filing the application, that will be covering your invention, and you can say that this is falling under my invention or my patent.
Okay, so basically, provisional application is that application if your research work is not properly done, and you know that this invention is very important for the society, so you can file a provisional application. Moving to further. Okay, so another one is ordinary or non-provisional application.
So this is the application there where you file when you are having the complete research data of your invention, and you are done with your research work. Then you can directly file a complete application that will not having any propriety. The filing date of this application will be the priority date, or you can say that priority date coincides with the filing date. And this application has claims also. So provisional application is not mandatorily having a set of claims, but complete application or ordinary application should be filed with the claims only. So this application is not having any reference to any other application which is under the process. Next. So complete application is the complete form of the provisional application. Like you have filed the provisional application on 1st of October 2022, and now you want to file a complete application, then within 12 months, which is 1st of October 2023, you can file the complete application with the same information and the claims. So claims are very important to be filed with the complete application, and this application is published with the patent office. It is examined, and this application goes to the grant. Provisional application never goes to the grant.
Yeah. So complete application is like when your research work is done and you have every claim, your novelty, you have drafted your document in a well-profined. Anyone is asking any question? Okay. So then only we file the complete application after filing the provisional application. Yes. So these are the part of like this. That was the half application. This was the full application. Now, convention application.
Yeah. So convention application is the application that you file in other countries. Like there is a convention of a set of countries that have an agreement that okay, within 12 months you can file your application in our country when you have filed the application in your home country. Like if I have filed my application on 20th of October in 2023 in India, and I am doing my research work, so within 12 months, that is 28 October 2024, I can file a convention application in US, Europe, China, Japan, and many convention countries. So we get the time of 12 months to work on these research work and proceed for the grant in those countries. So this is more or less like the complete application, but for other countries, not for India.
PCT
and the different kind of application is the PCT application. This is an international application. So this application, through this application, you get the validation in 142 countries, and you get the report of your status of your invention, like novelty, inventive step, and industrial applicability in those countries. But after 31 months, you have to enter into specific countries. So there are many few advantages of a PCT application, that a single application can be filed in different countries. You get a priority date and you get a long time of 31 months to get into different countries. Another importance is you get the search report or the status of your application, and it gives you a fair idea of your application about the patentability, and then you can decide about the entry of your invention in other countries. So it majorly it provides a longer time to think about the business idea or the countries you want to enter.
Okay, it's
This is
just like a
cost
tunnel.
effective also.
Yeah, it's just like a tunnel to enter in any other country, because patent rights are the country bounded rights. Whenever you wanted to secure your rights in other countries, you have to file another patent in each and every country. Like if I wanted to secure my patent rights in America, if I already filed my and got the grant in India, but again we have to file that particular application in America, then South Africa, then Germany, then Australia, to get our rights reserved in those countries as well. Okay, so PCT national application.
Yeah, so this is the next phase of PCT application. Like when you file a PCT application within 12 months of filing the application in India or any home country, then when you have the search report in your hand, you have the status of your application in your hand, then you can enter in different countries like US, China, Japan, South Africa, any country from 142 countries within 30 or 31 months, and you can protect your right in those countries, and you will get the priority of your application of filing the application in your home country. So that is the major benefit of filing an PCT application and entering through PCT initial phase in those countries.
Right. Okay, any question to anyone? You can write in the chat box. Okay, no questions. Now, flow
Yeah,
chart.
so this is a comparison of Paris Convention, or you can say convention application or a PCT application. Like you have your application on a 0 point of time. Like today you are having a idea. You have filed your application in India. Now you want to enter into different countries. So you will, within 12 months, you will enter into different countries. So it will be very costly also. You have to bear the translation. You have to bear the official fees for examination in every country. But for PCT, today you have the idea, you have filed the PCT application, then you will get the search report of about the status of your application. Then you will get a long time of 30 months or 31 months for entering into different countries. So that is the major role of PCT, that you get the longer timeline, and this is cost effective. Like you get, before entering into those countries, you get the status of your invention, that how inventive is your invention, how novel is your invention, whether it is good to enter into US or whether it is good to enter into EP with that invention. So another kind of application is a divisional application in India. So like if you have invention which is not having unity, like a process and a product. So product is having a different advantage, and process is having a different inventive feature. Then you can file a divisional application. Like you file the provisional application or a basic application. Then you can divide out your application and file a divisional application through the parent application. So that will be called as the first application will be called as a mother application, and the divided out application will be called a divisional application. So this application is considered as a separate application, but having the same priority date. So you will not have to hinder with your priority date. It will be having the same priority date.
Okay,
Next.
basically, this application is like if you have you have already submitted one application, you know that you have to put some other claims on and file other applications. So this application is the best for you. For
Yes.
example, I'm a parent of two children, and it's like we are creating a child and parent node.
Yes.
Okay, patent of addition.
Yeah, patent of addition is also a different kind of application. It is also a child application for the parent application, but in a different way. So, like if you are having if you have filed a patent application and within 15 months or say, or 2 years, you feel that something can be done additional to the application we have filed. So you can file a patent of addition for that. And if that invention is having some inventive step, then that application will be filed for with the same priority date. But this patent of addition has something different with respect to divisional application. And the thing is that the patent of addition will expire with the parent application. Like when if you have filed the parent application in 2020 and now you have filed the patent of addition, your life, the life of the parent application will be 2040. So the life of the child application or the patent of addition will also be 2040 only. It will not go beyond that. Whether you are filed in 2023 or whether you are filed in 2024. And no renewal fees is to be paid for the patent of addition. It will go along with the parent application. So this is the flow of the application: ordinary application, convention application, and PCT initial phase application. Next slide. So for an ordinary application, we have to provide the name of the applicant, address proof, nationality, name of inventors, and the address proof of the inventors, nationality proof of the inventors, and the complete provision of whole disclosure of the invention. These are the formal things we are required to submit.
These are like there are some certain of forms that we have to file during filing these applications. This is going to be the Form 1 application, and these are the information that we required while filing the Form 1. Okay. Convention application. These are
Yeah,
the
for the same
Same.
things we require, but it varies according to the country's requirement. Like for US, the requirement can be different, and for Europe, the requirement can be different.
Right, because the patent is IPR is country bounded. If the rights and the terminologies are different in each and other countries.
Yes.
PCT national sales application.
Yeah, so the PCT application has the earliest priority date. It is having a PCT application number. So international filing date is the date of application for the PCT application. And the English translation of the prior provisional complete application has to be submitted with the PCT, along with the abstract drawings and all the data which we have submitted in the basic application has to be submitted with the PCT also. So this is a comparison of between PCT and divisional and patent of addition. Actually, like divisional and patent of addition are for India only, and they are for the unity issues and the improvement issues. And PCT is for an international application or a application, PCT initial phase application, which we are going to file after the PCT application in different countries.
Here we have ended the information regarding the PCT application and other application, like types of application in India and in other countries. Like there are ordinary application, conventional application, non-conventional application, PCT application, and other applications.
So here you can see that divisional application is for the unity issue, but patent of addition is for the improvement. So here is a very thin difference between patent of addition and the divisional application. And so these applications are very different applications.
So again, now we are going to switching the slides to other information, like our trademark and other information. Just give us a second.
అడగాదు.
Okay. I would like to request everyone, please turn off their mics, because just give us a minute. Okay. So now we are going to discuss other things. We have already discussed tangible, intangible, and what is patent. Now we are going to discuss. My screen is visible to everyone.
Yes, sir.
Okay.
It's
So
visible.
we have discussed what is patent and what are the applications in that, and what is trademark, what is copyright, what is industrial design, what is plant variety. Now we are going to discuss about what is trade secrets. Have you ever knew like what is the difference between Pepsi, Coca-Cola, and Thumbs Up? Do you know what is the difference between all of these? Is patent grant? There is a question. Dheeraj is stronger. Which patent grant early, design or patent? Okay. I would like to clear one thing, Mr. Stronger. Patent, like I already discussed with you. Here is IPR. Okay. There is IPR. And IPR having certain departments like patent, trademark, copyright, industrial design. Industrial design is a part of IPR. Patent is also a part of IPR. Trademark is also a part of IPR. Your question is like, which patent grant earlier, design or patent? You are using both terminology, and you are means patent is the parent and patent and design patent is the child. No, IPR is the parent and patent and design are the child of that particular IPR, intellectual property rights. Yes, design registration and acceptance of the design is more faster than patent because design does not have any technical aspect. It is like anybody can file a design. For example, I in my mind there is a design of a magical bottle which can produce immortal water. Okay, so I am going to make a magical bottle like this, and whenever I'm going to drink it, I'm going to be immortal. So yes, design registration and acceptance of design is faster than patent application, but while filing each and every process, yeah, there is some cost of registration, government cost, and the professional cost which people will take. Okay, Dheeraj, we are stronger. Any other question you have, you can ask in the chat box. Now, trademark, trade secret. Sorry. Thank you very much, Mr. Stronger. Okay. My slides are not moving. Okay. My question was that, do you know any difference between Pepsi, Coca-Cola, and Thumbs Up? Because Pepsi have the facility. How to apply patent design in Coca. Yes, I will tell it to you. Okay. Okay. So there is something. Trade secret are the secrets that we are not mentioning it anywhere. There's a news that we can hear about. There is a lady who disclosed the fundamental information of Starbucks on online platform. So these are the like that's why people always sign the confidentiality and the IPR whenever any of the person joined. Okay, so yes, any employee joined any organization, there are some term and condition where we cannot use and like what we can know that, like we cannot tell to anyone the confidential rights of any particular thing. So any particular information which is important to the company is not disclosed by any particular employee to anyone. So that was the thing that disclosed by that lady. So trade secret are the majorly those secrets which consist the formula, the process, the method, tools, pattern, and automation. For example, I have a formula to make Oreo biscuit. I have a formula to make Pepsi. I have a formula to make Thumbs Up. These all formulas are crucial ingredients which are not going to be disclosed to anyone. These rights are considered and registered in the trade secret section of intellectual property rights. Okay. any process of making anything. If I know I can make idli from, not from even, I can make idli from water. So if without using any other ingredient. So this is going to be, this is going to be something which is novel, which is not going to disclose to anyone, because that was my idea. So these rights also comes and registered in the trade secret method. Have you ever seen the pattern which is printed on any sari, suit, dupatta? These all information are going to be like what we can see registered in trade secrets. And automation processes, like there is some automation process which is okay. Have you ever seen have you ever seen JCB in your life? What is JCB? Anyone knows what is JCB? Anyone heard about JCB? There is a huge machine, JCB. Have you ever seen any other company making JCB? Why we known as it is JCB? Anyone? You can write in the chat box. I think everyone knows like what is JCB. JCB is a company name. Have you ever seen that machine any other company making? Right. Have you ever seen like any other companies making that particular machine? Why? Because every part, each and every part of that particular machine is registered under the IPR. Each and every part. Nobody can make JCB. Everything is patented. Each and everything. That is why nobody in India and in for other countries are making the similar machine. Whenever you see any machine is making anything like which is doing this work, like construction work, no, JCB will be there, but not of any other company, right? So where we are, trade secrets are the secrets, ingredient, formula, patents, and everything. Now we are going to the next step. Okay, layout design. I will tell you about layout design. Geographical indications. Somebody is asking what is geographical indication. Okay, everyone knows like Nagpur ke oranges are famous for something. Kanchipuram sari is famous for something. Pashmina shawl is famous for something. And Bikaner ki bhujia is famous for something. And Darjeeling tea is also famous for something. So what is the common here? Anybody? Darjeeling tea, Kanchipuram sari, Kolhapuri chappal, Tirupati laddu, Nagpur oranges, Bikaneri bhujia. Why these rights are giving the indication to particular city or state? Sir, voice not coming suddenly. I'm audible to everyone. Am I audible? Hello? Okay. Perfect. So,
Okay, sir.
Okay.
Yes, sir. Audible, sir.
Okay. Kanchipuram sari, Kolhapuri chappal, Tirupati laddu, Nagpur oranges, Bikaneri bhujia. Why these things are famous? Why these cities are famous? Why? I never seen like Delhi is famous for something. No. I never seen like Trivandrum. I never seen like Hyderabad. Hyderabadi biryani is famous, but not is registered in geographical indication. I never seen like some state in UP, some city in UP is famous for something. Why these things? Why? Okay. The answer is okay. Okay. So now the answer is because the production of that particular thing, tea, sari, chappal, laddu, orange, and bhujia, it is working in a huge manner. Every person who is living in that city, for example, I'm living in Kanchipuram. Okay. Every person who lives in Kanchipuram are working and manufacturing saris of that particular the traditionals. Like for example, I'm living in Tirupati, and every person, even each member from a family of 5, there is each member who is working and manufacturing the Tirupati laddu. For example, I'm living in Nagpur. Not every person in Nagpur, the production of Nagpur oranges are very famous, and those oranges are not present in anywhere, like in any other city. That is why oranges are more famous by the name of Nagpur oranges. Bhujia is famous in Bikaner because people who live in Bikaner are manufacturing bhujia into the mass level. And that is why, that is the reason they have registered themselves into some city geographical indication. Geographical indication is like, if I am living in Delhi, I'm creating some boundaries that nobody can manufacture that particular thing out of this boundary. You cannot manufacture Kolhapuri chappal in Delhi. You cannot manufacture Kolhapuri chappal in Hyderabad or in Kerala. No, you cannot, because there are certain of rights that they have already registered in geographical indications. This is all about geographical indication. Any questions regarding this? The voice is not coming. Is my voice is not coming to everyone?
No, sir, it's clear, sir. It's clear.
Okay. So any questions on this geographical indication? Even you can make your city more popular if you are manufacturing that particular thing into the mass level. But it depends on only the how you are manufactured, that what thing that you're going to manufacture. Okay. Now, layout design are like, have you ever seen construction designs, blueprints and everything? These are all things are registered into the layout design. That is very simple. Okay. Any questions till now? And okay, we forget about copyright.
Sir, this product produced in anywhere else? This type of products
Yes.
manufactured in anywhere else?
No, never.
Never.
We cannot, I cannot make Kanchipuram sari in Delhi. No. Have you ever seen, like, from which city you are? From which state you are? May I know?
Yes, sir.
From which city you are?
Yes, sir.
I'm asking, you are from Kerala, Karnataka?
Yes, I am from Kerala.
Okay, you are from Kerala. You cannot produce Kanchipuram sari in Kerala. No.
Yes, sir. Yes, sir.
You cannot produce Tirupati laddu in Kerala. No.
Yes.
Because there are some boundaries that already restricting these, because due to they have registered in geographical indications. Okay. Now other thing is copyright. Okay. Have you ever seen, like, some people are claiming on YouTube that giving claim on some videos, copyright claim on some artistic work. So basically, on which thing that we can take copyrights? Okay, no doubt, sir. Okay, copyrights is a very like important in our society, because, for example, I'm creating some story. I'm writing some poet. I'm a writer. I'm a poet. I'm a poet, or I am a person who sing very well, and I have some steps that I can produce from my own dance. I have some particular musical composition. I have some films, artistic works like painting, drawing, photographs, sculptures, architectures, advertisement, map, technical drawings, and manuals. These all are things comes under the Copyright Act. Copyright registration. For example, if I am a filmmaker and I made a very good film, so what I get first thing that I will take a copyright. So any other person is not going to take it. People are making the combination of trademark or copyright, like trademark is similar to copyright. No, all these are different from each other, but the main thing is the parent of these things are IPR, intellectual property rights. Any doubt to anyone? Because I think session is going to be clear. Okay, there is one more slide, like maximum protection years, how we can protect these rights. No, there are some few more slides on which I will tell you how we are going to file these things. Patent have 20 years of protection, maximum protection, and every year we need to renew it. Trademark has lifelong, but after 10 years, we have to renew it. Design have 15 years, 15 years like that. 10 years, after 10 years, we have to renew it. Copyright have 60 years, not required, no renewal is required. Geographical indication lifelong, but after 10 years, we have to renew it. Okay. Now, patent filing type of forms and other things. There are the major things that we are going to discuss, like which form is important and why do what are all these forms, and these all are the forms that we require while filing a patent application. I am just telling about the patent application, no design application, no the copyright, no GI application. I am just going to tell you about the patent application. This is the flow chart of that particular thing. First filing, then publication, pre-grant opposition, initial. This is for the early publication and early examination, and everything is early here. Okay. A request for examination, then assurance of first examination report, filing response, then we file the response, then we will get the grant. If not getting the grant, there is hearing. If hearing is not here, what we have to do? We have to satisfy the controller that our invention is novel, sophisticated, industrial applicable, and the drafting procedure of that particular application is so smooth that anybody can anybody can understand what is your invention. Okay, so these are the things that we have that we are going to discuss in these things. And after, if you satisfy any person, if you satisfy the controller of your application, then you will get the grant for a trademark, for copyright, for design or for patent application. You just need to satisfy your controller. Now, types of application that will be required. New application, Form 1. Form 1 is for the new application. Form 2 is for the provision and complete specification application. Types of application we discussed with Ms. Swati version. Form 3 for statement of undertaking under Section 8. Form 5, the patent rule and declaration of inventorship. Request for Form 1, 2, and Form 18 and Form 9. Even Form 1 and Form 2 is most important for provisional and ordinary applications. Form 18 for a request for examination. For example, there will be no examination after 18 months. And after the normal time period of it was for publication or for any application 18 months. If you file Form 9 early publication, so we get the design. We get the publication within 2 months. If we not, it will take 18 months. Request for examination. There are 2 methods. First for request for examination. Another was like early express request for examination. If you file for request for examination, they will have like 3 months, 4 months. But for the express, it will like one month or 1.5 months. Okay. Mandatory from Form 1, 2, 3, 5, and 18. That's it. Okay. So where we have to just give me 1 minute. Okay. So where we have to, somebody was asking one question like how to file a design application. For that, you need a DSC first, digital signature. Everything is online now. Apart from that, you need an illustrator. If you have an illustrator, if you have some photographs of your particular design, for example, this is a mobile phone. You have 7 angles, 7 illustrations, like 1 perspective, 1 front, back, top, bottom, right, and left. After getting all this information, you need to go on IPR website, IP India website. Sorry, it's not IP India website, but this is okay. Here you e-filing of design. Okay. Now password 1IPEC. And it's wrong. 27W. It's I or L, I don't know. It's I, not L. BK. 1H2. Okay. Now, this is for the design application, not for the patent application. How we can file a patent application? First, go for the new application. You need a DSC, IDC class. There are some classes. There are some classes in which your application and your invention or your design is going to be considered. For example, I have made up a brush. So first I will write out brush. What? Travel and goods and cases, like we have a briefcase, something like that. Then ordinary application, convention application. Then your personal information, applicant name, and if we have multiple applicants, add other applicants here. Then articles, your design name and on which the particular design is considered. For example, in briefcase, in travel goods, cases, parcel and personal, I have a briefcase. So select briefcase here. Then on which address you are going to be communicate with IP India. So here you have to fill that information, then submit. Okay. There is no form history, I think. Okay. After this, you will upload other documents. Save. You will upload other documents, and rest is fine. This is the process. But for this, you need illustrator. You need attorney's signature, or you can file as an applicant as well. You need DSC, but anything which is not related to this, because it's a legal process, and everywhere whenever you go for the legal, you need some drafting procedures. You have to go for the basic drafting procedures. If you are unable to do that, then your application will be discarded and your money will be wasted. Okay. Any questions till now, anyone? So we will wind it up, and I would like to invite Deepa again. So there is something important Deepa will be going to discuss with you. So any questions till now? I'm here for the questions now.
Yes, sir. There is one query from my side.
Yeah.
Sir, can we do patent in concept rather than design?
Concept rather than design.
If I have some new idea or new theme, which I have mentioned in my research paper, can we patent it?
If it is novel.
Okay.
Okay. Let's make it more clear. For example, in India, you can publish any document. Can you guys please turn on your camera so we can click some like photographs as well? Yeah. So, for example, if you have anything like your thesis, even you have some information, you can take it till publication. But after publication, it is not going to be grant if it is not properly drafted, if the claiming statements are not good, or if the information that you are providing to the IP India is not novel. So I think your information, maybe your money will be wasted. If you want it till the publication, it is okay. Your mic is on mute. Dr. Mindro, you are on mute.
Sir, if it is published, then it is okay. If
Yeah.
it is not further proceed for grant, then it is okay or not? It will be considered for API or not?
First thing. Okay. For example, if it's a thesis or if it's a research paper, it is already published somewhere, right? You have already created a barrier for you first, right? Then you are taking it for the patent.
Okay.
Are you getting my question?
Yeah.
You understand Hindi?
Yeah.
Okay. It's like आपने अपना barrier खुद बना दिया, because while submitting application for the patent, the things must be novel, never ever registered anywhere, right? You have already registered.
Agreed, sir. But my question is, if I have not published my research paper from anywhere, and
Yeah.
if we want to make a patent,
Yeah.
then the registration process is okay, or
It's okay, but
we have to further proceed for grant.
yes, it's okay. It is very much fine. But the claims that you are providing and writing in the draft must be novel. वो novel होने चाहिए. Okay. And another thing is, like, after getting the examination report, everything will be cleared. Like, you have to proceed for that particular thing or not. If there are allowed many claims that are discarded by the IPR, then stop there. You have to be happy with the publication.
Okay. And one more question, sir. In
Yeah.
which category of IPR we can write it? I mean to say, the various part of IPR you have mentioned in your slide.
Okay.
So content patent, in which category we can?
If a technical patent, if you're technical, if your idea is a technical, it is going to be in the patent section. If it is an idea,
yeah,
it, like, for example, it is a process, it's a product, it is going to be under the patent. For example, if it's a bottle, nothing, there is no technicality.
Yes.
It is going to be industrial design. Okay. For example, you have an idea, if you have any information, like if you have something which invention is going to be like air conditioner, like a laptop, something technical, right?
Sir, if it's not technical, then in which category?
Then it is going to be industrial design. Industrial
just
design.
concept. There is no
Right?
technical design.
It is going to be industrial design. Like I have invented a lipstick. You have in your hand there is a lipstick. So I invented a design which have 4 lipstick containers. I got the grant on that.
Sir, but it is a design. But my question is, if there is a new theme, suppose that there is a new theme regarding entrepreneurship, we have a new theme, something regarding cutlery, then in which category we can put it?
Design category.
Design category.
Right. It is also it's not like you have not registered any patent or any IPR. Yes, it is novel. You can sell it as well. Like if we talk about the IP monetization, you can earn like I'm not happy with the piece of a paper where I got the grant and I'm going to showcase on my wall. I have more than 100. I want money from that. For that, there is IP monetization. I can sell my property, even design, even trademark, even copyright in lakhs.
But it is possible after getting grant, or we can proceed it with before getting grant?
After filing the application, you can proceed for the IP monetization, even you are not getting the grant. Because you know that, for example, from the date of filing, for example, I filed my application 28/10/2023, right? 28 अक्टूबर 2023 में मैंने application file किया, right? Now somebody else made up the similar design in 31st of October, on 30th of October, right? And after I got the grant first, basically, right? After getting the grant, I come back and I was like, I'm going to sue you, mister, because I got the grant, I have the grant. You can earn money there. Plus, you can, for example, you made up this watch design. You designed this watch. Okay. So you will you go to the you will like you connected with the Titan company or Maxima company, who is the manufacturer of a watch, and you were like, I want to sell this design to you. If they are interested, they will buy your design in lakhs. If you have like you are talking about the cutlery, for example, I made a plate, right? I made up a plate which already after putting some food, it start getting heat, producing heat. This design is also going to be published in like sell or by purchased by any company who is manufacturing plates. Simply, just take some designs. Even I made up I made up an exhaust fan. I made up some like mop. I already done that. I made up like four design patent I have, which is already based on water bottles only. It does not matter. Just secure your IP, whatever you have. Because in today's scenario, AI is also producing a lot of things, but AI does not have brain.
Right.
We have.
Okay, sir. Thank you so much.
Thank you, ma'am. Any other question? Feedback link. Hema Malini, ma'am, you will get the feedback link from Deepa. Sir, suppose any design is copyright done. Design, but then it is possible to industrial design. Okay. Artistic work can be, only the artistic work can be copyrighted, not the design. Industrial design have the 3 axes, like for x-axis, y-axis, and z-axis. I can touch it, feel it, then only it comes under the industrial design part, because industrial design is already means by like industry. It must be applicable in industry. It can be anything. Okay, another question. Sir, tell me real-time example of where we using IPR everywhere in mobile phones, water bottles, even like in our shoes. There are more than 100 of, even in a car. Like for example, even if it's pushing one switch, even if you like pushing any door, even we are some clothes like kurta, like sari, whatever the things. We are using IPR, guys. But the main factor is we don't know that. We don't know the things. Have you ever seen any industry? Just go to IPR section and check it out. Everything like shoes, sari, plates. There was a person. I just saw that like there was a person who made up a plate. Okay. In first plate, in first invention or first design, there was 2 flowers. And another invention, there are 3 flowers. And they have 2 IPR. Because there are 2 flowers and there are 3 flowers. Everything can be IPR. Right? Everything, each and everything can be like secured by IPR. But you have to use your brain. Like I would like to invite ladies. There are a lot of things that what is IPR? What is intellectual property rights? And what is entrepreneurship? What is startup? Nothing. Don't focus on the organized sector. Focus on the unorganized sector. Wherever you feel that you are unorganized and you have to organize that in an automation process. Like sometime I was like sitting with my mother and she was like, काश मेरे पास ऐसा होता जिसमें मेरे हाथ में खारिश ना होती जब मैं कोई प्याज काटती. I made up a gloves. Simple. So there are a lot of invention that you can do by sitting at your place, your home. I have done my 20th invention. I was sitting on my sofa. If what things that my house want, that must be in my house. Whenever I open my door, there were a lot of dust. So I made up some stick and putting some like what we can झाड़ू का वो कुछ होता है वहां पे लगाया something like. And whenever I'm opening a door, all the dust particle will be went to the side of that particular door. Simple. I was seeing my friend carrying multiple lipsticks. I made up an invention where she can carry 4 lipstick in one container. I am seeing my friend who's carrying 2 bottles. One is hot for water and one is for cold drink. I made up one bottle which is having like a partition. Half bottle is for the cold drink and half bottle is for the water bottle. But I increase the diameter for 1 liter. Simple. You can do any invention, guys. But the thing, nobody is interested in these things. People right now in today's scenario, I see a lot of students who are investing their time in entrepreneurship startup. This is also a startup. Whenever you made up a product, you sell it out and you created a startup, you become an entrepreneur. You have become a businessman. What is a businessman? This is a businessman. This is a businesswoman who have created one invention. One question. Okay, sure, ma'am. You can turn your mic on as well. You all have information. You all have the rights. Anyone else? V. Sujata, you can ask the question. As I will take it to Deepa. Any question? Thanks you for clear my doubt. Thank you. Okay. Anyone else?
Good evening, sir.
Good evening.
Sir, I have one doubt, sir. Actually, I missed your class starting onwards.
Okay.
I taught IPR for the BTech students. IPR means intellectual property rights.
Right.
Yes, sir. Sir,
Right.
it talks about her rights in the be a law, which is we learn in the political law. Like some sections are there for the intellectual property rights.
Right.
For example, if we design anything of any product or like now only you said like a bottle, like a pen, whatever
Right.
you want to design.
Right.
So if in case she is a minor, then if it is used to others design product or any other things, so how can we act on that rights on that particular product?
For example, as I got your question, if there is some person who is minor, right?
Yes, sir. Yes,
For example, I am 16-year-old.
Yes, sir.
Okay, and I have invented something. I have invented one pen. Okay,
Yes.
and somebody else is also using that pen or already invented that pen. Then, right? This is your question.
Yes, sir. Yes, sir.
Okay, so I think the little girl or the little boy is not going to get the grant because the older person is already having that invention. If and if the little girl have invented a pen and that older guy is invented a pen after that minor girl, right? So the little girl can sue that particular person. Even I am 4 year old and I invented something. There is no restrictions. Whenever you are filing a form of IPR, there is nothing where you put your date of birth.
Okay.
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 Any other question?
No, sir. No, sir. Thank you, sir.
Thank you. Anyone else? Should I leave? I need a glass of water now. Okay. So anyone else? I would like to like thank you all, and I am requesting one thing to you. Dr. Bindu, you would like to ask any question?
Yeah, sir, what is the difference between design patent and utility patent?
Okay. Utility patent is like does not exist in India, first of all.
Okay.
Like many, my personal suggestion was like many of the people was like many professor was like, I want a utility patent. I am doing on utility patent, but no, there is nothing in India. There is only one terminology is patent. The process patent and utility patent, these terminologies are existing in America. But the process of getting the grant in America is like if you mistakenly put one dot in your drafting process, your 2-3 lakhs are going to be gone. The getting of registration process in America is very strong, very difficult.
Okay.
Utility patent is something else. Process patent and utility patent all are the similar thing. On utility, you are securing your rights on some utility. Process patent, you are securing your right on some process, like point 1 to B, B to C, C to D, algorithms. Some people are like, have you ever seen like copyright on website? In the end of that website, copyrighted by 2023 to 2024. But we cannot secure we cannot secure any code. We cannot claim any code because code is open to industries, right? For example, I invented like hash include iostream.at. You cannot use that iostream hash include iostream.net .iot, right? You don't have any right. This is your personal thing, na? Right? फिर तो आप यूज ही नहीं कर सकते. But no, कॉपीराइट उस पर्टिकुलर डिजाइन के ऊपर हुआ होता है जिसको लेआउट डिजाइन कहते हैं कि वेबसाइट दिख कैसा रहा है. There are some sliders, there are some sections, then tab bar, filled like there is some screen frames. That is going to become under the layout design and be registered there. Simple. IPR is the father and the mother of all these things. Simple.
Right.
When I learned all these things is very difficult, but I made simple for me. What is this? So there is a lot of sections, a lot of things. And one more thing, any person who wanted to start career in intellectual property rights, it is very simple. Have you ever heard about like UPSC, IPS, IAS? Right? Okay. These all are the non-technical jobs for A-grade officers. Right? Non-technical, like there is no technicality. If you are a BTech teacher, I am a BTech teacher, I'm a BTech, MTech, PhD in computer science. I can be a patent controller, patent examiner. On what was the rank of that particular person? A-grade officer, having a bungalow, a car, a bodyguard, everything. But nobody knows about this because everyone wants to become an IPS, IAS, right? So UPSC controller was a A-grade officer, but in the technical field. Simple. UPSC, UPSC person who is having the non-technical job, IAS, district collector, magistrate. Simple. So there are a lot of opportunities IPR as well. Become IP agent. You can earn money like the money that you are earning in 3 years, you can earn that money in 6 months. So it's totally, and if you want to become an IPR person or IPR agent, you must be a person from technical background. You must be a BTech, BCA, MCA, MTech, PhD in computer science or any technical mechanical engineer or something. You must be an engineer to become an IPR officer or examiner. Okay. So any other question? Okay. What is? Okay. Shall I leave now? And please turn on your cameras for only for 10 seconds, so I can take a screenshot. Please, everyone, can you do this? Yeah, thank you. Few more. Okay, thank you so much, guys. Thank you so much. Over to Deepa. There is something important. Deepa is going to connect with you guys. Bye bye. How was the session? You can write in the group as well as in the chat box or anywhere. I hope you guys enjoyed the session. Bye bye.
Share the PPT.
You will get a link on YouTube channel because all these things are live on YouTube. We will give you the link of that YouTube channel. Okay. You can connect with Deep as well for the PPT. Bye bye.
Thank you, sir.
Thank you.
Hello, everyone. I hope you enjoyed the session. Hello. Hello. I hope you have enjoyed the session. How much it is? Is it useful? Is it knowledgeable? Have you got something new? Yeah. Okay,
Yeah,
this is what we are looking for. And we are going to organize such webinars time to time. And we will definitely going to, share the links with you of the webinars. Today, after all session, I would like to share something with you which is very important in terms of knowledge as well as for the monetary purpose. So, because as have you gone through with this webinar and you understand what is IPR is and how it's going to help you, I would like to draw your attention here for one thing that through this IPR or through with this your intellectual property, you can earn also. And from very beginning, right? Before you make a grant or go for a grant of any design, you can also start earning with by joining us as our become our associate or become our team member, right? So here we have gone through with some of the some of the steps, or you can say some of the options for you, or would like to say it is an offer of earning or by staying in your current job. You don't have to put extra time, you don't have to come out with your current job. You by just sitting at home, just using your network, you can earn money. Okay, so as you know that you have gone through with the values hello the commercialization of your patent. Once you get the grant, you can go for the commercialization of your patent. So this point we are also going to cover in this part. So here the first thing is that we will go for the 100% cash redeem model. What is this? If you're having the people, like you all are from, like you are a professors, you are assistant professor, you are PhD holders, and you are also from the R&D department. So this is what we have to go like this. R&D department people, PhD holders, and the associate professors definitely having their own network from the different criteria, and they can go for the different designs also, right? Suppose someone from the agriculture, someone from engineering, someone from life science, someone from chemistry, physics. So there are so many criteria. You can connect with everyone and create your own network. Why this network is needed? Because when we come out with our ideas, we want to share our ideas with you. You can come up with us by your own ideas. Okay, we will discuss it with you. We will, if I have to go for design, we can go for the design also, but that idea will be your side. This is the one thing we are talking about. The second thing is that we are having some own our own ideas, like we are going to make it public in front of you. You just come and participate in that patent and be the part of that patent. How? Suppose I come with the one design with you, and that design will goes like, you will be the part of this design part. Hello, hello. So yes, we are talking about the design part. So on that basis, we are saying you can connect with us. Okay, now I just want to extend this leg. How? We are talking about the IPR workshops. We want you just make your one step ahead for us. And what is that one step ahead? That you can start a workshop. You can some technical issues there. Okay, so we just want you to be our associate partners. You can come up with your ideas, we can come with our ideas, and we want you just share your links with us, so that we can create a associate team with, and we can start with different options of earning, as well as the patent part also. Okay, thank you so much, guys. I'm at the end of this PDF. You will see one of the scanner. You can scan this QR code. You will find a form. You can fill it up and send it to us. And I have shared our links and other social media information on the chat also. Hello. Already given. So I've shared it again. Please go through with these links. What link done?
బావా బావా
Thank you all of you for joining us. Please give your valuable feedback to the group, inside the group. We are waiting for your feedbacks. Thank you for this evening. Thank you for joining us. And we are looking forward to work with you. We are associate partners. Thank you so much.
Thank you. Thank you.